Mr. Bender, you may proceed.
May it please the court. Chief Justice Cady, the Associate Justices, Counsel, good afternoon. I am Bradley Bender. I'm here to represent Mr. Majors on his appeal. He is a juvenile resentencing case. It's just one of the many that has came down since the Lyle opinion and the trilogy of other cases that have come down by this court. The broader framework that this court needs to address, I believe, is in light of Sweet. Are the Lyle factors even applicable in a mandatory minimum sentence? I know that's not the issue that I presented in the further review that I filed with this court. I took the approach I took with the original brief I filed with the Court of Appeals that was argued, which was the court did not apply the Lyle factors, and even if we assume they did, they were wrong in their interpretation of those factors. This court does have that general question that needs to be addressed first. In light of Sweet, what do we do with these cases that we have with shorter mandatory minimum sentences? Because that question needs to be answered first before we get on to the questions that were presented in this appeal. I do think that question is before this court, in light, even with me not properly arguing that in my application for the review. I know Justice Apple raised that issue in Field versus, I think it's Borkowski, where it talks about if it's an intertwined issue, this court does have ability to address that issue.
We heard on that issue this morning from another attorney, as you may know.
Yes.
Not someone with your office, but someone else who had been appointed.
Yes, and I do think that if you, in the Roby case that was argued this morning, I think that the court, if it takes the interpretation that and follows a Sweet line of reasoning that the Lyle factors are not applicable and that there's a categorical rule against mandatory minimum sentence.
Well, what is it about your case that would illuminate our decision on the categorical challenge?
Well, I think Mr. Majors, he presents the case where we can see why we should not have mandatory minimum sentence for juvenile offenders. Here is Mr. Majors was 11 years removed from his sentencing date when he had his resentencing hearing. And the court in this case went through all these different factors. They went through 8 factors. They didn't apply the Lyle factors. They went through 8 different factors. Every time.
Is there anything wrong with that? I mean, look, under Lyle and Miller, there are a number of factors you have to look at, of course, in mitigation. But does that mean you can't look at anything else?
Oh, no. We're not saying that he can't look at anything else, but you have to take them as mitigation first, though. In this case, the court, if any opportunity he could hold something against Mr. Majors, he did. He presumed it as an aggravating factor. There was no mitigation that was going on in this resentencing. And, you know, the clear-cut issue that I think that's why we should look at these categorical rule is the district court in this case used against Mr. Majors the fact that he committed 55 violations since he's been in prison. Most of those violations was due to substance abuse issues. The issue in this case on what was committed as the crime, there was some allegation that methamphetamines, drug use, alcohol use was the reason for the commission of this crime that he's in prison for. The state's own exhibit shows that from the Department of Corrections that Mr. Majors is not allowed to participate in substance abuse treatment in prison at this time because of his mandatory minimum sentence. He's not allowed to participate in the victimization counseling program because of his mandatory minimum sentence. So we have a juvenile offender who's been in prison for over 11 years, who's not getting no rehabilitation because of his mandatory minimum sentence. And the idea for when we impose any sentence is that we hope that they are rehabilitated, they're given the opportunity for rehabilitation, and that when they do eventually are released from prison, that they do not recidiate.
Counsel, you make the general argument that the district court failed to apply the Miller-Lyle factors. with respect to one of those factors, the age, I tend to agree with your position that the court seemed to use that as an aggravating factor rather than a mitigating factor because he was so close to 18. But with respect to the other factors, what is your complaint about the court's
Well, he
failure to
told-
apply the other ones?
I'm sorry to interrupt you just a sec. With respect to the family background factor, let's just look at that factor alone. Here we have very limited information on family background. You look at the PSI that was prepared as part of this exhibit. I think there's one little small 3-sentence paragraph that talks about the family.
So that's not the court's fault, that's counsel's fault, right?
Well, I think that's what the problem we get into with these mandatory minimum sentence in juvenile resentencing. What are the obligations of defense counsels here? What is the obligation of the state? Who has the burden of proof in this case? Because when we are looking here at this juvenile resentencing, what we have here is Mr. Major showing up for a hearing. We have his attorney who's put on 2 witnesses. We had the state put on 1 witness. We have 2 exhibits admitted. We have no report on Mr. Major's psychological background. We have no report on his family and background. Nothing was prepared. We have no investigation report on show exactly what kind of rehabilitation that he has taken in prison. All we have is just one small report from the Department of Corrections. His counselor never testified. And I think that's when we get in these Miller line of cases, in the Lyle line cases, that, when we have this mandatory minimum sentence, defense counsel, this is a whole new ballgame. This is not you just show up to court with a nice little, couple of pages, you stand from the court, you give a 5-minute presentation, and you sit
Isn't that
down.
exactly what happened here? More than 5 minutes, only a little bit more than 5 minutes, and only a little more than 5 pages. And we had the same situation this morning, frankly. The record in our 2 cases, Roby and Majors, is relatively thin. Majors a little more than Roby. But is that an ineffective assistance of counsel claim? Is Lyle that hard to understand?
Well, the presumption is mandatory minimum sentence. We're against mandatory minimum sentence. That's the presumption. That's what this court has stated.
Where do you get that presumption on once you move away from life sentences? What case of ours has said there's a presumption against mandatory minimums?
Well, I think it's not in just one case. I think you have to begin with Lyle. I think what we have to look at is the understanding the reasoning in Lyle. What this court looked at in Lyle was, it's not juvenile offender, life without parole, juvenile offender with shorter mandatory sentence. This court made its determination was juvenile offender versus adult offender. And I think that same reasoning applies in this case here. Because in Sweet, the court pretty much categorically ruled that life without opportunity for parole should not happen. If we take the Lyle reasoning and apply it to this case, we should not look at the category of youthful offender. We look at the youthful offender. Because if someone's serving life without possibility of parole and someone who's serving a long prison sentence, they're in the same position. And because the whole idea here is the brain development. We worry about the juvenile offender. We worry about the maturation process. We worry about whether or not they have properly processed their ability to become, what they're doing. And if with those same concerns that this court recognized in Sweet, is same concerns that could be applicable to a shorter mandatory sentence, because we're looking at the juvenile offender by themselves.
And Lyle talked about all that and said the solution is we need to give discretion to district courts. Unless I'm misreading Lyle, it didn't say there's a presumption against mandatory minimums. It just said you have to have a hearing with the 5 factors considered before you can impose one, right?
That is true, but then I think you can't just read Lyle in isolation either. You have to look at what was stated in Sweet, because I do think Sweet does provide additional framework, because, in Sweet to talk about how do we apply those factors.
Well, Sweet said that they were too difficult to apply, and therefore there should be a categorical rule, and I guess that's your position for all mandatory minimums for juveniles, is that right?
That is right, because I think that what you have here is I don't want to criticize the district court too much in this case, but my reading of the record is pretty much that he had to predetermine what the sentence was. He was going to reimpose the same sentence. And what he did was he tailored the facts in his ruling to support that reimposition of the sentence.
I don't read the record the same way, but to the extent that happens, that probably happens pretty common in sentencing. The judge has a sentence in mind and then makes a record to support the sentence that they have in mind. I want to ask you about the age issue. In this case, the defendant was 15 days short of 18 at the time of this home invasion, right?
That's right.
And the judge the court took that into account, and I guess you're saying it took it into account in the wrong way. Is it your position that assuming that age is a factor, since we've said that, the U.S. Supreme Court has said that repeatedly, if age is a factor, and then you have a situation where this person is at the very top end of the age continuum for juveniles, why can't the fact that he's at the top end be taken into account?
Because I think then it would totally diminish what this court has previously said in Sweet and Lyle and stuff, which is that, we look at the brain development, and we're saying that, they don't fully, the brain doesn't fully develop until the early 20s here. And so what we're
Should we drop the age factor altogether? Take that off the list of 5?
Well, to me, I personally think the age factor should not even come into account here when we're talking about juvenile offender. Because if you're a juvenile offender, you're a juvenile. And we know that juveniles do stupid things. And in this case, if you look at Mr. Majors, he had no prior history with the criminal justice system except for this case. But we do know that he had some unfortunate circumstances that was going on. He had, some chronic substance abuse problems. He had some chronic issues that, was happening. Now, the court diminished those.
There was also other evidence. I mean, I don't think this was that brief a hearing. I think it ran on for about 60 pages, and there was testimony from one of the victims, and apparently there was evidence that Mr. Majors had stalked the wife for a period of time and then planned this with carrying the 22 and the machete, anticipating that she would be alone and the husband and the little kids wouldn't be there, and then was surprised. I mean, I think there was some evidence that this was a seriously pre-planned crime, wasn't there?
That was on a victim impact statement that was gave during the resentencing. It was not subject to cross-examination. That was the victim coming in.
No, the husband came in and testified, I thought.
There was an officer who came in and testified, but the exact details that you were giving was more in detail than the victim impact statement, because that went on for several pages of the sentencing transcript.
Okay, I see your point.
Let me just ask this. The district court judge said the most prominent single factor was he was 15 days short of 18. We said in seats that when you're age 16 and 17, that doesn't undercut the Miller notion and so forth. So that may well be wrong. And then the district court also criticized the lack of substance abuse treatment, but of course, if you're not approaching release, you don't get substance abuse treatment. And as I looked at the record, at least, there was no indication to suggest that he actually had declined substance abuse, although that somebody will correct me if I've missed it. But why, let's assume that with this, why isn't the answer to remand or correct or to point out the kind of the problems in the application of the Miller factors and get it fixed? I mean, you're suggesting no, that's kind of a fool's errand. We're picking the wings off flies. You can't do it. But tell me why it wouldn't be adequate to just police appropriate application of Miller factors.
Well, ultimately, this court will must make a decision. If this court doesn't want to go that route of a categorical rule.
I want to hear your argument for it.
And however, if the court doesn't want to go that route, then I think the easiest resolution to this case is to remand this case back to district court and to instruct them to apply the Lyle factors as mitigating factors. And, because that's what we asked for in our original brief in this case.
What kind of hearing do you envision going back? I mean, if you were the defense counsel down there representing Mr. Majors, what would you do? And you don't have to tell me the substance of it, but procedurally, what would you want to present to the court if you could?
Well, Justice Wiggins, first of all, I would get him a psychological evaluation and have that presented to the court through testimony at a hearing with a report and having the psychologist there. I would employ an investigator to investigate the background, have them come in and testify regarding the background, deals with family or education. And I would also, you need to show the court, you know, what's been going on in the Department of Corrections, because they're going to use, in this case, they used it against him. Going back to what Justice Apple said, if you look at the court's ruling here, the court specifically said that Mr. Majors turned down programming, but there's nothing in the record to support that, because the state's own exhibit says he's not eligible for it until he's majority, his mandatory release date. So I do think that you need to present the court with more than what was presented here, because this is a whole new ball game. I think, you know, since this sweet opinion came down, you know, myself, I've reviewed the law review articles, and I've reviewed, you know, 10 CLEs, and, you know, they tell you what you need to do based on how this law is evolving and what you need to do to properly represent a client in this situation. Fortunately for me, I argue in front of you guys. I'm not down in trial court level. But I do think that, I see my time has expired here. Is there any other questions you want me to ask at this time? If not, I'll wait to rebuttal.
Mr. Bender, thank you. Mr. Sloven.
Thank you. Thank you, Mr. Chief Justice, and may it please the court, counsel. So Sweet decimated the Miller factors, is what the Court of Appeals said. I think that's true with regards to their value in terms of predicting future dangerousness, at least for the duration of an offender's lifetime. I still think that the Miller and Lyle factors are useful here for what they're intended to do in a Lyle hearing, which is evaluate whether the circumstances associated with youth mitigate the offender's culpability for this offense. That instead of being...
Mr. Sloan, put yourself in the position of a defense counsel. Might be tough, considering what you've done, you know. But put yourself in the position of defense counsel. What type of hearing would you envision, and Mr. Bender gave us his view, what type of hearing would you envision that and preparation a defense counsel should do in order to properly present the Miller factors or the Lyle factors or any mitigating factors?
So I think that there's a lot of different ways to approach it. I think the bright line rule should be if evidence is not favorable and doesn't show mitigating value associated with youth, don't present it. The Court of Appeals noted when it ruled on the PCR claim that Mr. Majors filed before that, excuse me, he had received a psych eval prior to when they were preparing for the trial on the first time around. I don't know what the results of that evaluation were, but I would assume that defense counsel before this resentencing at least had access to that and would have known, right? And that's just one example of how we don't know for sure what defense counsel decided not to present.
I'm sorry to interrupt you, but a sentencing hearing is different than a hearing of determination of guilt. And good, bad, or indifference, when they get a PCI report, it's in there. Good, bad, or indifference. What's wrong with, you know, everybody says, well, you have to advocate for your client and you have to do this. But if you're going to fairly present the factors to determine how a youth should be sentenced, shouldn't the good, bad, and the ugly come in and let the court do its job after hearing the good, bad, and ugly, making those things? I mean, at a minimum, maybe a court should require a psych evaluation or investigate or do some of the things. But we're not talking about determining guilt or innocence. We're determining about how a court may exercise its discretion, if it's discretionary, or exercise its powers or requirements under the Constitution to figure out whether or not this kid is entitled to be relieved of the mandatory minimum.
I would agree with the idea that as much relevant evidence as is available that bears on culpability or mitigation should be introduced. I think that this doesn't change that defense counsel has a lot of latitude in terms of deciding what's going to be beneficial and what's not going to be beneficial. There's going to be strategy in terms of what to present and what not to present. I think that if you look at this case, there are going to be a lot of factors associated with the family and home environment that aren't great for Mr. Majors to be presenting. And then you talk about substance abuse. Mr. Bender referenced that. Mr. Majors, after his arrest, it took a long time for him to make any statements about substance abuse at all, and then he made statements that were kind of beyond the pale, not really credible about how this offense was produced by methamphetamine use.
Is it fair to say that he didn't turn down, let me put it this way, there's nothing in the record to say that he turned down substance abuse treatment?
Yeah, I don't think the record says that he turned it down. I would say that turning down substance abuse or getting into it versus repeatedly making homemade alcohol in prison, one of them, I think that you can still consider his continuing violation of prison rules, maybe, and under the Lyle analysis, not as aggravating, obviously, because nothing's aggravating under a Lyle analysis, but it can help to show that his chances for rehabilitation get less of a mitigating weight. That
Didn't he have two different kind of versions at the time? One version was, I was on methamphetamine, I blacked out, I don't remember. And the other version was, it was all a prank and somebody paid me $100.
That's right. That was the prank is what he first told the police that evening, I think, and then later on it became, in time for the PSI report, the substance abuse. And there's also some testimony or something in the record about him inquiring about, with other inmates, about how to fake psychological symptoms that would help him make a case for mitigation.
Now focus. There was one factor that of the five in Lyle that the court didn't discuss by my recollection, and that is the challenges for youthful offenders in navigating through the criminal process. And that's not discussed. I don't think defense counsel below presented much on it. I don't think Mr. Bender has said much on it in his briefing other than it wasn't really covered below. Let me ask you about a concern I have about that specific factor. Originally, Mr. Majors made a deal that he was going to plead guilty to attempted murder and would get this 25-year sentence. And part of the deal was he wasn't supposed to appeal. And as I read the record, what happened is he then filed a pro se appeal that looks very crudely done. And as a result of maybe the not best decision in the world to file this pro se appeal, he was in breach of his plea agreement, and then the 10-year term for the burglary was ended up being tacked on in addition. Can we say that now he filed the pro se appeal, he was already 18 at that point in time. I don't know how that washes out, but can we say that maybe that's an example of the challenges for youthful offenders in navigating through the criminal process?
My hesitancy to do that has to do with exactly what you said. First is that he filed that appeal when he was 18. My other problem is that he still got a great advantage from that plea deal. He got, I think that in the aggregate, he faced over 100 years for all of the offenses that he was charged with, and then the plea deal brought that down to 25, even if it only brought it down to 35.
That's not Justice Mansfield's point. I mean, his point is, this is a little erratic. You didn't use that phrase quite. Let me use it. And so he comes up with a plea bargain, then he withdraws, then he turns around and accepts it. It's like whipsaw and
Right.
ending up to his disadvantage, and that it may not control the whole works because the Miller has 5-prong test or whatever. But on that particular prong, there looks like there's some evidence that impetuosity and youthful inexperience and difficulties adversely affected him. Now, maybe you don't weigh it very heavily, but doesn't that look like kind of erratic behavior?
Sure, I'd say that the impetuosity that he showed when he was 18 impacted the sentence that he ultimately faced.
Let's talk about this 18 business before you go on. And that is,
But if I could just interject, on the same topic, doesn't it also reflect on what his level of functioning was and sophistication before he was 18. Presumably, he didn't get worse after he became 18, right, in terms of his sophistication and his judgment about navigating the legal process?
I suppose that's probably true. My biggest problem with that Miller factor is I don't see a lot of connection between difficulties faced in navigating the legal process, especially in this context, and culpability. If what we're supposed to be evaluating is the circumstances associated with youth mitigate his culpability for the offense, in the words of Lyle, does this help to show that punishment is actually appropriate and necessary or not? I don't really see this factor impacting that. I think if you go back to how that factor came into the case law, it has to do more with the problems with imposing a categorical LWOP sentence on a juvenile offender that while adults in the system...
I think there's a legitimate question whether it's relevant here because at this point he was 18, so it was not conduct engaged in as a juvenile that he suffered a penalty for. But I do think, as I read Miller, when they were talking about that consideration, they're talking about that kind of thing. That is, youth who make poor criminal defense decisions or no decision at all, and therefore end up with a harsher penalty than an adult would have been who is sort of more cagey and more seasoned and knows how to handle the criminal process. Is that fair?
I think it's fair to say that the additional 10 years might be an example of him making a decision that somebody more mature and more developed might not have made. I still don't see the connection to culpability or mitigation. I want to talk about the defendant's age because the treatment of that factor got some attention during opposing counsel's argument. So I'm starting on page 10 of the resentencing order here. The first thing that the court does, it says age is the most important factor, block quotes null. Then it has another paragraph when it says, here's how old the defendant is. He was 15 days away from his 18th birthday. In theory, he would be less impulsive or impetuous. Then there's a paragraph where it says, it doesn't look like he's substantially matured during his time in prison. And then there's the critical paragraph where it says, the facts of this offense don't tell the story of an offense where that age mitigates. That this isn't an offense that's characterized by impulsive behavior. He acted alone. There's no peer pressure. None of the ways in which juvenile offenders, particularly juvenile offenders who are 16 and 17, none of the ways in which their decision-making makes them less culpable, those don't appear in this case.
How can a court come to that conclusion without some psychological evaluation to get behind what he really did and why he did it?
Well,
I mean, there was some explanation one way or the other.
Well, I think the facts of the case really spoke for themselves in a lot of ways, that this was very meticulously planned. It involved a lot of observation of the Peckhams, not just daily, but weekly routine to find a time when he could infiltrate the house, wait, and then get an opportunity when he thought, and it looked like this almost happened, that Jamie would leave the house with the 1.5-year-old twins to drive them around until they fell asleep. That's planning. That's that's taking time to form the plan. And I went and got this book that you cited in Sweet because I was interested in the same question. Why do such smart adolescents do such stupid things? And on page 77, there's discussion of some really interesting science here, that when circumstances are ideal, when there's no distractions, no strong emotions, a 16-year-old performs just as well on decision-making tasks as an adult. That by the time you're 16, you've gotten through that second step of the brain development process in the prefrontal cortex, the myelination, the little bit of the synaptic pruning, and that without the peer pressure, without the hot-blooded decision-making process, your decision-making is on par with most adults.
Oh, yeah, but of course, if you read the entire book, as I know you did, they go on to say that the mere fact that the cognitive skills of a 16-year-old and 17-year-old, of which I have some familiarity with, are quite good, but risk evaluation and emotional judgment and temperament and so forth are different and are not developed. And indeed, in Seats, we talked about adolescents, quoting from Scott and Steinberg, adolescents, even at age 16 and 17, are immature in their psychosocial and emotional development, not cognitive development. The cognitive development supports your planning business, but the psychosocial and emotional development are not mature, and thus likely affects their decision about involvement in crime in ways that distinguish them from adults. And in light of the science, this is reading from Seats, the fact that a defendant is nearing the age of 18 does not undermine the teaching of Miller and Null. So,
And I think that's true in some contexts, but when there's time to really engage the more analytical, the higher functioning decision-making processes, that kind of reduced culpability associated with youth gives way to an analysis that looks more like what adults would use in the same situation. That's what the science really shows. And I'll give you another example of something that well, maybe we can move on to a different issue if we're just going to disagree about science, but
I'm not sure I agree completely with the science, but I'm
Well,
open if you want.
I guess what's more important, and one of the problems that I have with that discussion is that it ignores the moral dimension, right? There may be an emotional decision-making part, but whenever we talk about their cost-benefit analysis being bad, or it really ignores the fact that the benefit that Majors put on the scale here, the thing that he set out to achieve, is really inherently bad. That it's something that it's not about his decision-making skills of any kind. It's about the object that he set out to achieve and put a lot of effort and planning into getting there. And I think that if you're going to take an individualized look at these juvenile offenders, you're going to analyze the offender himself and the offense and the age at which he committed it. You really have to look at what the facts of the offense say about whether they demonstrate mitigation or not. And the fact that he was this age and committed an offense that looks like this with this amount of planning doesn't help him make an argument for mitigation. I think the district court was right to assign no mitigating weight to that factor
Why do
under
you
the
think,
circumstances of the case.
on page 41 of the transcript at least, the prosecutor suggests that if there's not a mandatory minimum, he'll be out in parole. The parole board's going to let him out. If his record is as unattractive as you suggest, why would the parole board be releasing him?
Well, I don't know if the state could have said that with any certainty. I do know that his tentative discharge date would definitely change and become, I think the date ends up being late 2019. At this point, his earliest eligibility date for parole, I believe, is late 2020. I think that, I see my time's expired.
You may sum up.
Thank you. I think the most important thing to do with this case is give guidance. It's appropriate to consider the facts of the offense as long as, separate from that, there is an analysis of the ways that the circumstances associated with youth mitigate or don't culpability for the offender. And what Lyle said is court should impose the legislatively prescribed minimum punishment if warranted. And I think district courts should be free to make that decision. Thank you.
Mr. Sloven, thank you as well. Rebuttal, Mr. Bender?
Yes, Your Honor. May it please the court? I do want to address a few issues, a few questions that did come up regarding especially the challenge of the criminal justice system that was talked about. And I think if you look at exactly what happened with Mr. Majors here is that we have a sentencing hearing, the original sentencing hearing, and it was just at the end of that sentencing hearing, he orally makes a notice of appeal, knowing full well that it will be in violation of his plea agreement. He did have a discussion with his parents and his attorney at that time, according to the record, and he withdrew that so he could stay with the plea agreement. But then less than a month later, he calls his attorney and asks to file a notice of appeal. And I do think that alone signifies the immaturity that we have going on here with Mr. Majors. He's not savvy. And, for the state to stand up and say, well, he must have a sound mind in order to plan this, this incident, action that he did. Then what's the difference if this was a murder case? They have to have planning and premeditation in that case. And we, in this court, has stated in those type of cases that the mandatory minimum sentence does not apply. So I think, what we have to look at here is the facts and the age aspect here. And I do think that the state is minimizing what this court did. Because this court pretty much said, Mr. Majors is a lifelong criminal. And if you can, that is a perfect summation of what the district court stated in its resentencing order. Every chance it had to ding Mr. Majors, it did. It looked at the fact that it micromanaged how he stood up and gave remorse to the victim during the resentencing hearing. Because he didn't look at the victim.
It was unimpressive what he said. I mean, for considering he's had all that time to think about it, it was not a particularly remorseful or lengthy statement.
Well, I think that can go back to him being able to challenge the challenges of the legal system here. What exactly
No,
is he
he's
supposed
not,
to say?
now he's well away from being a juvenile at this point in time.
But the thing is, though, he was placed in prison in his 18th year. He has spent the rest of his over 11, 12 years having the resentencing hearing in prison. He has not gotten any rehabilitation. He is now being indoctrinated in the lifestyle of being a prisoner, and he comes back to court. We don't know what was said. We don't know what was said between him and his attorney. Now, when I was a trial attorney, I mean, yes, you do caution your client if you're going to say something, make sure it's tactful, that you don't want them to get up and just spout off, but you can't force them what they say. You can't write out for them what they say. And if he
True with
doesn't have
adult
the brain
clients,
development...
and that's true with adult clients too that
Oh,
you
yeah.
have.
I mean, there's many adult clients, there's times where I wish I was trying to pull them down, but I mean, at the same token, hey, it's their right to say what they want to say.
Can I interrupt you
Sure.
for a second here? Is sentencing in Iowa an adversarial proceeding?
I would not personally take that as that. My idea of when I was doing sentencing was you present the evidence to the court, you give, of course, you're going to slant the evidence to the best, to make your client look the
But
best.
the legislature has said you have to have a PSI, which is not presented by one side or the other, allegedly by a neutral side. I mean,
And it's going to contain bad and good information most of the time, and sometimes more bad than good. And, you know, you do try to have witnesses, but at the same token, I mean, you know, in a juvenile resentencing, I think, you know, you need more evidence in the record than less evidence.
and what would be wrong with the court ordering some of the things you talked about?
There's not-
Psychological investigations, investigations into the background and all that other things. Present those reports to the state and to the defense attorney. And just like they argue over the PSI, let them argue over those things and put on additional witnesses in order for the court to fully understand what really happened in this case when making their sentencing.
There's nothing wrong with ordering that. But the problem is, though, we have different judicial districts, and I have practiced in the different judicial districts, in the third and the second, and they do things different. And I think that, you know, unless we make sure it's mandated and there's a proper framework, we're still going to have the problem where what happens in Sioux City is going to be different what happens in
The Constitution requires it, it's gonna be done the same in every district.
well, you would hope, and that's the one thing that I think, you know, as long as it's done that way, I personally think in these type of cases, you need more evidence than less. In this case, Mr. Majors was disserviced by his attorney in this case, because I think, you know, the court failed to appreciate all the factors as was presented. It failed to give him the mitigation that was necessary, and I think that, you know, this court should return a decision that the district court in this case erred, and that this court should, at a minimum, return it back to district court. Thank you.
Mr. Bender, thank you as well, and Mr. Sloven, thank you again. State versus Majors is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.